Hey, what's up, everybody? News Now Wyoming, bringing another episode. This is going to be one of a three-part series here. I'm going to try to record them all. As I was thinking about how I would put this together, and I was researching about malicious prosecution, there was just so much to uncover here. As you guys know, in one of my recent videos here, I really railed against the judge's decision. And even after reading all of this case law, I still disagree with them. But really, the question at the end of the day is, where does this idea of malicious prosecution come from? Where do they pull their thoughts together? And so what we're going to do here is a three-part series. This first video, we're going to look at the only few cases where the Supreme Court has actually covered malicious prosecution, which there isn't a lot of case law there. I really want to dig in there and find out, how do they define it? How do they look at it? And so that's what this first video is going to be. The second one is going to be to look at how all the federal appeals circuit courts have dealt with this issue, right? All the circuits, every circuit is treating malicious prosecution differently. So I want to look to see I want to show you guys exactly how that looks. How did the First Circuit, Second Circuit, how do they all define them? Because every single one of them defines it differently. When can it be dropped? All completely different from one another. Ridiculous. And then in the third video, we're going to look at a case that is going to be argued in November of 2021 that sounds like it's really case in point on the one that we just covered on malicious prosecution. And so the Supreme Court may actually define what in your favor actually means. So here we go. We're going to first look to see what malicious prosecution is, look briefly at a few of the cases regarding it. There are quite a few, like I said, there's only a few cases where they even touch on it. And so here we go. Malicious prosecution occurs when a police officer or other government official causes a criminal charge to be filed against a person when the official knows probable cause is lacking and the charges are filed because of personal animosity, bias, or some other reason outside the interests of justice. In such cases, the victim's 14th Amendment right to liberty has been violated. 14th Amendment, that's important, okay? God, that's ridiculous. One of the ones we're going to review. All right. Malicious prosecution is a common law, intentional tort seeking damages resulting from the institution of or continuation of criminal proceeding for an improper purpose and without probable cause. The tort of malicious prosecution has also been extended to the initiation of civil, administrative, and disciplinary proceedings. For various public policy reasons, actions for malicious prosecution are not favored by the courts, but they are necessary to deter the malicious initiation of criminal proceeding without probable cause. It is generally litigated under state tort law, while many lower courts recognize some form of malicious prosecution under 32 U.S.C. 1983. The federal circuit courts of appeals are split on this issue. There is a divergence in opinion among the circuits as to whether malicious prosecution standing alone can violate the Constitution. Although each jurisdiction may define the cause of action for malicious prosecution differently, the elements of the common tort are generally: 1, the institution or continuation of a legal proceeding, either civil or criminal, or an administrative or disciplinary proceeding against the plaintiff I better show you guys. That's the flag, so nobody yell at me for my flag. I love the flag. I do love my blue line flag. But that's what it actually looks like back there. By the instance of or abated by the defendant, the termination of such prior proceeding in the plaintiff's favor, the absence of probable cause for institution of prior proceeding, malice as a primary purpose for that proceeding, and some injury or damage to the plaintiff as a result of the prior proceeding. So there we go. Some of the case law here. Again, there's not a lot. I did find another one that is referred to somewhere else. But we've got Heck versus Humphrey. And in this 1994 case, here's the quick one, right? While petitioner's Heck's direct appeal from an Indiana conviction was pending, that's important. He filed this suit under 1983 seeking damages, but not injunctive relief or release from custody. So in this one, they were very quick to deny it because under the common law of malicious prosecution, the case has to come out favorably in favor of the plaintiff. So they were really quick to deny this, because in order to recover damages for allegedly unconstitutional conviction or imprisonment, or for other harm caused by action whose unlawfulness would render a conviction or sentence invalid, a 1983 plaintiff must prove that the conviction or sentence has been reversed on direct appeal, expunged by executive order, declared invalid by a state tribunal authorized to make such determination, or called into question by a federal court for issuance of writ of habeas corpus. A claim for damages bearing that relationship to a conviction or a sentence has not been so invalidated is not cognizable under 1983. The foregoing conclusion, and again, the foregoing conclusion follows upon recognition that the common law of torts provides the appropriate starting point for the 1983 inquiry. See Carey v. Fifus. That the tort of malicious prosecution, which provides the closest analogy to claims of the type considered here, requires the allegation and proof of termination of the prior criminal proceeding in favor of the accused, and that this court has long been concerned that judgments be final and consistent, and has been disinclined to expand the opportunities for collateral attack on criminal convictions. Alright, so here we are on Carpenter v. Nutter. This is a case back in 1899. That's how far back malicious prosecution goes. Here in, as far as I can tell, in the court, right? In the Supreme Court. So, facts are stated in an opinion. Action to recover damages for malicious prosecution. A demurrer was interposed to the complaint in the court below and sustained. Judgment was thereupon entered in favor of the defendants. This appeal is from the judgment upon the judgment roll and blah blah. So where they get to, where was that at? So in actions for malicious prosecution, it must be alleged that the prosecution is at an end, either by alleging that the defendant was acquitted of the charge or by alleging facts showing the legal termination of the prosecution complained of in favor of the defendant prior to the commencement of the action. The rule, as stated above, has always prevailed both in England and in this country. That is, a necessary rule founded upon reason is apparent to the legal mind. Proceedings in court having jurisdiction of the person and of the subject matter must be shielded from collateral attack. In all cases where such proceedings have been regularly taken against a party sustained by the court in which it is pending, it is conclusively presumed when collaterally assailed to have been regular and valid, although in fact it may have been erroneous. If the rule were otherwise, the judgment of course would have no efficacy, as they would be subject to impeachment wherever an attempt was made to enforce them, and would leave disputes between parties forever unsettled. So here we go with if it had been alleged that the information was dismissed by the court, the facts would have to be alleged in such a manner as to show that the dismissal was an end of the prosecution. It is an elementary rule that the allegations of pleading will be most strongly construed against the pleader. In no case can the court, in face of a demurrer, presume any facts to exist except such as stated in the complaint. The plaintiff in this case was in fact discharged by an order of the Superior Court of San Joaquin County, and the order was such as to end and finally determine the prosecutions under the information he could have so alleged in his complaint. He has not done so under the law as we understand it. It becomes unnecessary to consider any other questions in this case. So here's where that idea of unfavorable dismissal. You can be found not guilty. A judge can dismiss it with prejudice. Somebody has to say you are innocent, which is a very, very high bar, because how let's go back to the case that actually pissed me off to begin with. How would you ever reach that point unless they actually prosecute you, take you to court to rule that? The cops did wrong. They did bad, and they did it solely because he flipped them off. That is the only reason he was prosecuted. The only reason. There is no other reason. And the court even found that it was malicious, or not that it was malicious, that it was against his First Amendment rights for freedom of speech. So, with that, and the prosecutor dismissed it, didn't say why. But so again, this makes no sense. This is 1899, so it's really hard to read compared to now. Then we come to the Manuel versus City of Joliet, and this one, if I remember right, 2016-17. Elijah Manuel was a passenger in a car that was pulled over for failing to signal on March 18, 2011. When the police officer detected an odor of marijuana in the car, he dragged Manuel out of the car, pushed and kicked him, and handcuffed him. The officer found a bottle of pills in Manuel's pocket during his pat-down. The pills were tested, and the officers falsified the results to show the pills were ecstasy. Yes, the officer falsified the results to show that the pills were ecstasy. The initial positive pill results were later tested at the scene of the arrest. More detailed negative lab results were presented by Manuel later. Manuel was arrested based on these initial results. The officers continued to rely on the false positive initial test throughout the grand jury proceedings, and he was held until May 4th, when the assistant state attorney sought dismissal of the charges. Manuel sued the city of Joliet and various city officials and alleged malicious prosecution as well as other civil rights claims. The district court dismissed most of Manuel's claims as falling outside the statute of limitations. So here's where our laws suck. For a claim under 1983, you have 3 years to file it. Okay, 3 years. So, and if you miss that at all, well, then you're just screwed, right? All right. So when can you file that? Well, that's an important question, and extremely stupid, because the date starts on the day that you are actually charged with the crime, or when they violate your rights. That's when that 3 years starts for most things. So the 3 year statute of limitation, but courts won't hear your case while it is still in action, while it is still a criminal case. So you can't file it until the criminal case is resolved, but the time starts on the day that they violate your rights. So it's really, really horrible. Manuel sued the city of Joliet. Where were we? His malicious prosecution claim was not time-barred, however, but was dismissed under Newsom versus McCabe, which held that federal claims of malicious prosecution stemmed from the right to due process and are not a Fourth Amendment issue. Again, it was dismissed because it was filed under the Fourth Amendment violation, not 14th Amendment. Therefore, there was no malicious prosecution claim under federal law if the state provided a similar cause of action as Illinois did. On appeal, Manuel argued that Newsom did not foreclose a malicious prosecution claim on Fourth Amendment grounds when officers misrepresented evidence. The U.S. Court of Appeals for the Seventh Circuit affirmed the lower court's rulings as consistent with the Newsom precedent. So the question, does an individual's Fourth Amendment right to be free from unreasonable search and seizure continued through the legal criminal case. Where the legal process has gone forward but has done nothing to satisfy the probable cause requirement, it cannot extinguish a detainee's Fourth Amendment claim. Notice Thomas and Alito. Thomas and Alito. I'm going to be ending up doing a video on why I feel Thomas is the worst and most unreasonable justice on the Supreme Court. I realize my fans on the right are going to hate me for this, but in matters of civil rights, in matters that I care more about civil rights and how we are following the Constitution than anything else. And he is most against holding government accountable of any other justice that we've had on the court. So I will be doing that video, not today. Alright. So, an individual's Fourth Amendment right to be free from unreasonable search and seizure continues throughout the legal process of a criminal case. Kagan delivered the opinion for the 6-2 majority. The court held that an individual's claim that challenges pretrial detention falls within the scope of the Fourth Amendment, regardless of whether legal process has begun. Even where legal process has begun, the prosecution itself may be unsupported by probable cause, which gives rise to a Fourth Amendment claim. In such cases, a detainee's Fourth Amendment claim does not become a 14th Amendment due process claim because the requirements of the Fourth Amendment have not been satisfied. The court held thus that Manuel's Fourth Amendment claim was proper because his arrest was made without probable cause. The court then declined to decide whether Manuel's Fourth Amendment claim arose when his criminal charges were dismissed or when legal process began, and instead remanded the case to the U.S. Court of Appeals for the Seventh Circuit for consideration. In his dissenting opinion, Justice Thomas wrote that the point at which Manuel's Fourth Amendment claim arose was irrelevant because Manuel filed his claim after the statute of limitations had run for either possible date. Samuel Alito wrote a separate dissenting opinion in which he argued that the majority had ignored the question of whether a malicious prosecution claim may be brought under the Fourth Amendment. At the point that Manuel brought his claim, the only timely claim he could have made was one for malicious prosecution. However, while a claim under the Fourth Amendment right to be free from unreasonable search and seizure is typically brought against law enforcement officers, officers do not initiate or dismiss prosecution, which is required for a claim of malicious prosecution. That's a horrible argument, Alito. That's not what the case law that even the case law we do go through in the next video is going to hold. So yeah, Alito is also sometimes stupid. Half the time stupid. Malicious prosecution claims also require subjective bad faith, whereas Fourth Amendment claims use an objective standard. Lastly, malicious prosecution requires a termination of charges, while a Fourth Amendment violation occurs regardless of whether charges are eventually dismissed or not. Therefore, Justice Alito argued that malicious prosecution cannot be based on the Fourth Amendment. So again, not very clear on the case law here either, right? I mean, there is no good federal Supreme Court case law for or against this. We also do have another one that's called McDonough versus Smith. And let me see if I can bring this over. Give me a second. Okay, so McDonough versus Smith, and this was 2019. So petitioner McDonough processed ballots as a commissioner of the County Board of Elections in a primary election in Troy, New York. Respondent Smith was specially appointed to investigate and prosecute a case of forged absentee ballots in that election. McDonough became his primary target. McDonough in this is very much in line with what we've been facing the last couple of years, right? McDonough alleges that Smith fabricated evidence against him and used it to secure his grand jury indictment. Smith then brought the case to trial and presented allegedly fabricated testimony. That trial ended in a mistrial. Smith again elicited allegedly fabricated evidence in a second trial, which ended on December 21st, 2012, with McDonough's acquittal on all charges. McDonough, and notice 3 years here, 3 years almost to the day, but 3 days before. So if he would have waited 3 days, he would have lost this case altogether. McDonough sued Smith under 1983, asserting as relevant here a claim for fabrication of evidence. The district court dismissed the claim as untimely, and the second court affirmed. The court held that the 3-year limitation period began to run when McDonough learned that the evidence was false and was used against him during the criminal proceedings, and he suffered a loss of liberty as a result of that evidence. Thus, the court concluded that McDonough's claim was untimely because those events undisputedly had occurred by the time McDonough was arrested and stood trial. It is held that the statute of limitations for his 1983 fabricated evidence claim began to run when the criminal proceedings against him terminated in his favor. That is, when he was acquitted at the end of his second trial. The time at which 1983 accrues is a question of federal law, conforming in general to common law tort principles, and is presumptively not always when the plaintiff has a complete and present cause of action. So, what they're saying here is when you've got a case, that's when you file it, and that's when that 3-year statute of limitations starts running. But again, this does not answer the question of malicious prosecution and did it come out in favor? Because yes, in this one, if we look at the actual opinion here, we're going to look at one of the footnotes. So the second court barred the common law elements of the malicious prosecution to govern McDonough's distinctive constitutional malicious prosecution claim, which is not before us. This court has not defined the elements of such 1983 claim. See Manuel versus Joliet, 2017. And this case provides no occasion to opine on what the elements of a constitutional malicious action under 1983 are, or how they may or may not differ from those of a fabricated evidence claim. Similarly, while noting that only McDonough's malicious prosecution claim was barred on absolute immunity grounds below, we make no statement on whether or how the doctrine of absolute immunity would apply to McDonough's fabricated evidence claim. Any further consideration of that claim is properly addressed by the Second Circuit on remand, subject to ordinary principles of waiver and forfeiture. So, basically, they even say they haven't defined the elements of malicious prosecution. It's all still up to the circuit. So we are going to look at what some of the circuits have found in the next video. That will be coming. It might take me a day or two to finish putting that all together. And then finally, there is a case coming up in November that we're going to look at a few of the filings on it, because it could overturn a lot of stuff. I'm hoping they actually make a very wide ruling. I doubt Thomas will change anything because cops can do no wrong in front of him. But anyway, you guys, there we go. I hope you enjoy this video. Make sure you catch me on the next one. Have a great day.